these live to YouTube so the public can join in. Looks like that's going. Okay. Last thing I need to do is read through our hearing script. This basically will just cover the procedure of the hearing, and then we'll start with the presentation of the applicant's case. So this is the August 18th, 2021 session of the zoning hearing examiner docket. My name is David Sturkey. I'm the zoning hearing examiner for the city of Cincinnati, and I'll preside over this hearing. The case before us today is case number ZH20210094. The purpose of this hearing is to allow applicants and opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any opposing party wishes to offer must be presented at this hearing unless a party is opted to submit evidence or testimony in the form of writing prior to this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent will first present the applicant's case. The public will then have an opportunity to speak after the applicant has presented its case. If the applicant is represented by an attorney, the applicant's attorney may cross-examine any person who has testified at the hearing. If the party of record is represented by an attorney, the attorney for the party of record may present witnesses after the applicant has presented its case and may cross-examine any person who has testified at the hearing. In the event that any party testifies or offers argument in opposition to the application, the applicant shall have an opportunity to rebut that testimony and or argument or offered in opposition. And after the applicant has been given an opportunity to rebut any testimony, an attorney for a party of record will have an opportunity to make a closing statement, and then finally the applicant will have an opportunity to make a closing statement. So just to summarize, we'll give the applicants slash owners, the school here, an opportunity to present their case along with their attorney. I don't believe we have anyone here from the public. I think everyone is represented in some form or fashion by an attorney. So I think at that point, we will have our zoning plans examiner, Walt Moeller, provide any additional testimony that he would like. And then we will give the neighbors and the neighbor's attorney an opportunity to present any evidence or testimony that they would like, and then allow for cross-examination. And I think I misspoke. The attorney, Ms. Couch, you'll have an opportunity to cross-examine anyone from the school after they testify. And then Mr. Carville, after the neighbor's witnesses testify, you'll have an opportunity to cross-examine them. And then Mr. Carville, after that, you'll have an opportunity to rebut any testimonies. So you'll be able to re-examine witnesses or allow witnesses to respond to any of the arguments that were made from Mrs. Couch's clients, the neighbors. And then you'll each get a chance to make a closing statement, and then we'll close. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions or to make any comments. I may also refuse to consider hearsay testimony or documents. This generally means evidence you want to introduce that consists of statements made by someone who is not present at this hearing. I do allow some of that to come in, but at my discretion, I can exclude it as well. In the event of any technical difficulties or any unforeseen circumstances, I may continue or postpone this hearing. That'll be at my discretion. We'll do our best to troubleshoot those on the fly, but to the extent there's some fatal defect in the tech that prevents us from meaningfully going forward with the hearing, I may continue this. Okay, I think we are about ready to begin. So last thing I'm going to do is I'm going to try to swear in all of our witnesses. So this does not include attorneys, but anyone else that intends on providing any testimony here today, making any comments, asking any questions, doing anything other than just strictly observing needs to be sworn in. And so, Ms. Couch, if there's any way that I could see all of your clients in one frame, just for this purpose, just for a moment.
Ed is going to be testifying, so he's right next to me, if that's okay.
Perfect, great. Okay, and Father King and Mr. Dooley, if you could take yourselves off mute. I need everyone to raise their right hand and answer out loud. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes. I do.
Yes.
Okay, great. Thanks, everyone. All right. So, Mr. Carville, I'm pretty open on how attorneys want to orient their case. If you would like to ask direct questions of the witnesses, you can do that in a more direct examination format, or if you just like each one of them to just take the floor and just provide testimony about the project and why it's appropriate, that's also completely up to you. So,
okay,
I'll give you the floor.
Yeah, David, as far as logistics go, are we looking at 15 minutes to present?
I typically will give folks more time than that. I don't. That's usually when I'll usually impose the time restrictions when we have a large amount of people from the public that
Okay.
are here. So I'm not going to enforce that 15 minutes.
Okay, I appreciate that. And for your benefit and the benefit of all involved, we summarized the testimony that we're presenting today in 2 affidavits that have been uploaded to the public correspondence folder and the hearing folder. Do you want to still hear testimony that is embodied in those affidavits?
It's completely up to you. If it's in the affidavits that are in the record and have been shared as a part of the application or sometime thereafter, then you do not. I mean, they will be considered and they will be read. They will be a part of the official record. So that's completely
Okay.
up to you.
Well, then we can certainly expedite things. I'm not going to call Ms. McElroy or Mrs. McElroy or Mr. Dully because they're just going to be authenticating and reiterating what's already contained in their affidavits.
Okay.
All right, David. As far as the presentation of evidence goes, I'll let Tim, if he has anything to offer anything at this point, and then I'll go into some discussion of the statutes, and then I'll just yield my time for rebuttal.
Okay.
Tim, I'm
Thank you,
prepared to.
Chris.
Yeah, go ahead.
Thanks, Chris. And I apologize. I use Zoom every single day. And I don't know why I'm having such a difficult time today. So I'm just going to be speaking here over the phone. Can everyone hear me okay?
Yes.
We can. Mr. McElroy, were you sworn in?
No.
Okay. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead.
Okay. Well, thank you all for your time this morning. We appreciate the time that you're taking to work with us on this potential project. This parish has existed for over 125 years in the same place. Certainly the campus has grown over those years, but I think it's very important to note, as the record states, that this area has been used for recreation, athletics, playground purposes for, as far as we can tell, based upon historical records, for about 80 years. So it most certainly predates perhaps most of the homes that exist on Brockman Avenue. We tried to look up records to indicate when those homes were built, but I don't believe they're accurate because the county auditor's records do not match the historical photos that we have for aerials in the area. Next, we certainly acknowledge that we did this unwillingly. We didn't know that there was a zoning variance or a zoning code that we were not in conformance with, because this area has been around so long as recreation and playground facilities. So there was certainly no intent to buck the city's zoning code or upset neighbors or anything like that. So, for that, we certainly apologize. We want to be a good neighbor. I think I can speak on behalf of the parish that that's certainly part of our mission, is to be good neighbors and to be good citizens. So it certainly doesn't please us that anyone is upset about something we've done in the past or want to continue to do to provide the opportunities for our school children and for neighborhood children who use these facilities as well. When we found out that this work was not in conformance, we immediately stopped. I think it's important to state that because I heard that I believe a concrete pad was already poured, and that is not the case. We took down the old playground, donated that to a nonprofit who came and took it away, and we began some excavation work and put up some wood forms to place a concrete pad. But that work was halted immediately upon us finding out that we were not in conformance. And I want to touch on the whole reasoning for this new play set. It's all about safety. The old playground was, I believe, 20 to 25 years old. It was beginning to suffer. There were some maintenance issues and some upkeep that was getting costly. And quite frankly, it just doesn't meet the new safety standards that exist for playgrounds and play sets such as this one. So through a long process, The funds were raised. This is not being paid for by the church or by the school. This was all private funding to get this completed. And we worked with a Cincinnati-based company who puts play sets like this one in all over the greater Cincinnati region and beyond. And it's important to note that this new play set does conform with all known safety regulations for similar play sets. This was done with a lot of research by Liz McElroy, looking at other facilities around the city to make sure that what we were doing was in line with what other communities and schools are offering their children. While I'm on the safety subject, I think it's important to know that we are proposing to relocate the new play set in a slightly different location than the old one. The old one existed and was located over mulch. And the new safety standard for these play sets is to use a rubber surface that's poured over an existing pavement. That's why we chose to put it in the proposed location on the existing asphalt surface. To do so where the existing playground exists today, or play set existed, would be a cost burden that, quite frankly, with the private funding that we had to raise to do this, we don't have the budget for. So that's why we chose to locate it where it does. It also works with the existing logistics that come with operating a church and a school. This area serves a lot of purposes. It's not just a playground. It's a parking lot. It's a parking lot for events, for weekly mass, for all school events, and it's also used for logistics in the morning. This is a parking lot and a driveway where a lot of our kids are dropped off. Buses come in a different part of the school, but there's a lot of car riders who come in very close to this area, especially now more than ever. There's a lot of parents who are electing to take their kids to school in a car rather than a bus, given the concerns of COVID. So, there was a lot of thought put into the location of this new play set, and we really don't have a lot of choices but to locate it where it's being proposed. I will note that it is not being located any closer to the property line. It's a lateral move, roughly 30 feet from the play set that's already been taken down. It's closer to our school. And moving on to another subject, the whole reason why we were told we needed this variance is because we're told this is considered a front yard. And we want to, for the record, disagree that we don't agree with that. Our front yard is Beachmont Avenue. Our church, our school, and our rectory all front Beachmont Avenue and have Beachmont Avenue addresses. We don't have an address on Brockman. So we kind of have to question this, the whole reason for the variance in the first place. We understand it may be the front yard to people that live on Brockman, but we do not agree that it's a front yard to Guardian Angels Parish.
Okay. Thanks, Mr. McElroy. I have a couple questions as I look through the materials here. I'm still having trouble figuring out where exactly this one is in relation to the old one. And in particular, if it's closer to houses, the Kramers and the Stewarts' houses. Could you answer those questions?
No, it is not any closer to the residents. As I mentioned, it's a lateral move. It's moving north, from a geographical perspective, which is 30 feet closer to Beachmont, but it is not moving any closer to Brockman Avenue or the adjacent residences.
Okay. I'm going to go ahead and try, just so I understand exactly where this is, because I can't seem from materials done to get a good overhead shot. I'm going to try to share my screen here. Hopefully this works. And Ms. McElroy, I assume you know where this is. It'd be nice if you could go off mute and since I'm sorry. Okay, you're both McElroy. I'm sorry. Liz, yeah.
Yes.
Can you see my screen?
Hold on. Yes, I can see it.
Okay. Mouse isn't working properly. Okay. Am I in the right location here in terms of the new playground?
Hold on. I'm on my phone.
Okay. Is anyone on the applicant owner side not on their phone or able to easily see my screen? Mr.
David?
Carville, do you know the answer to this?
Yeah, David, Mark Dulles could probably address your questions. And if I may, could I share screen and then toggle back, ask a series of questions, and then you follow up? Okay.
Sure.
Let's see here.
But if you could start with the overhead map so I can figure out exactly where this is.
Yeah, I will. Let me get the share screen function going here. Okay, can everyone see that?
We can.
Okay, great. Okay, so perhaps in the just to keep things moving along, I'll narrate and ask Mr. Dully if what I'm saying is correct. So if you look at Mr. Dully's affidavit here, which is GA Exhibit 2, this is an overhead shot with a cloud, okay, calling it out. We've got a little bit better photography here through Google Earth. All right, so here's Brockman. Is that correct, Mr. Dully?
Yes.
Okay, here's the church, here's the school, here's what we term the overflow lot. That's the location of the previous playground. Let me just walk through these to answer your question. Okay, here's an aerial showing the prior location of the playground, which is going to move laterally, like Tim said, 30 feet north in this direction. Does that make sense, David?
Yeah.
Okay, so to orient you further, here is GA Exhibit 7. This is sitting on the very end of Brockman, which goes from an kind of an asphalt to a driveway material here. This is the old playground, stand of trees that come through up to here. If you turn around and look, the playground would be off to your right, but 30 feet further north in this direction. And unfortunately, I think the best shot is the one contained in the right here in the staff report. Okay, if you go to the photograph on the second page, this is where the Brockman ends, and then that kind of asphalt material, driveway material begins. Does that make sense to you?
Yeah.
Okay.
It does.
Now here's the shrubbery.
Sure.
The playground's moving forward in a northerly direction, 30 feet, but maintaining this at least 17 foot from our property line, 17-foot buffer that then gets increased when you look at how much distance there is on this side of the property line.
Okay.
So
Can
that
you
is
go back to the overhead map real quick.
I can, David.
Thanks.
Is this the one you want to use, or the one that has kind of a southerly direction to it?
It doesn't matter. Could you put your cursor where the new playground's going to be?
Right there. So this sits.
It will still be behind that hedgerow.
Okay, but it'll be approximately 30 feet from the old one.
Right.
Is that right?
Yeah. So we're, Tim, correct me if I state this wrong, or Mark. This is all mulched in here. Okay. And the cost of preparing the substrate is very expensive. So we're moving the portion of the playground that needs to be have a strong substrate for the padding material for the kids when they fall. It would move in this direction, so 30 feet like this.
So where his cursor is right now, David, where that shadow is from that tree, maybe a little bit above that. So if you see that hedgerow to the left, that it will not. It goes about halfway into that. There's a light post out there.
Okay. And guys, let me jump in here. So this is where the play set, because I think the verbiage here is important. This is where the play set is going to be installed, correct?
Correct.
That is correct.
Okay.
Because it is currently
and
that playground.
let me ask. The rest of this parking lot is used as one larger playground when there's not cars there, or
Yeah,
that
so
right?
David, let me just moving things along. Mark can correct me, or Tim or Liz. This is kind of an overflow parking lot. That was its design in life. And when the parents come in to drop their children off, this is their egress. They come down here, and then they loop through in this area and come back here. So we're kind of constrained with, where we can place this thing and safely get kids in, or safely and logistically get kids in and out in the morning.
So my question is, during the day or during school hours, whenever kids are typically using the play set, or currently right now when they're using the existing play set, is there a portion of this parking lot that they're also playing on, or are they just limited to the
Yes.
mulched area at the bottom? So it looks like you have some basketball keys there,
Yep.
some squares.
Yep.
Are those for children to play on?
That whole area is for children to play on, and it is
And they
blocked off
have
with
been playing on
gates.
it?
Yes.
Okay, all right, thank you. That's what I
So
was.
currently, just to put a finer point on it, once the kids are in school, there are gates that will be closed. So that area will not be able to be accessed by vehicles of any sort.
And
then we
those are the
open them-
existing protocols.
That's correct. So
Okay.
once they use it to drop off their kids and the buses come through in the morning, we close the gates. They're opened in the afternoon for when the kids are picked up and the buses come through, and then they're closed again for our extended care program. So we run
Okay.
about 440 kids through there during the school day, and upwards to 60 to 100 kids in our extended care program.
And Mark,
Okay.
how long does this extended care run until in the evening?
Parents are expected to pick up their kids by 6.
Okay, and the school day begins around 8.
That's correct.
So 8 to 6 would be hours of operation with a recess in there.
Got it. Thanks.
And we're also using the spaces more and more with COVID learning spaces. We've extended our Wi-Fi out there so that, we're asked to be outside more and more often over the last year and a half or so. Or it's safer.
Okay.
I would say.
Okay. Mr. Carville, any other witnesses you'd like to present or arguments you'd like to make now?
Would you like to hear closings now, or just yield the
No.
floor and then, okay, then no.
Unless you have any other witnesses or arguments that you'd like to make or anything of that nature right now, we'll go ahead and give Ms. Couch an opportunity to ask your witnesses any questions if she has any.
I have nothing further, David.
Okay, great. Ms. Couch, anything you would like to ask of any of the applicant's witnesses?
Yeah, I appreciate it. Mr. McElroy, are you still on the phone?
Go ahead.
Yes, I am.
I just had a couple questions. You said that there were no other options for this. Has Guardian Angel looked into any other areas to place this playset?
We have, and this, after a long process, this proved to be the most optimal location for the reasons we stated, taking safety and logistics into consideration.
What were the other areas that you all looked at when you were determining that this was the best location?
We looked at the entire campus, but again, the pavement, the asphalt parking lot and the overflow parking lot has always been used for the playground. Due to weather considerations, you can't use a grass field for a playground. Maybe that works part of the time, but certainly not all the time. And our grass areas on our campus are also much further removed from the school building. So from a logistic standpoint, managing young children, that doesn't make any sense. And to pour this rubberized surface, it has to be on a hard surface.
And the school has a parking lot down on the other side of the building by the gym, correct?
Yes.
Did you all look at the option of pouring this there where you have the concrete already in place?
We did not, because quite frankly, as I stated, this area between the school building and Brockman has always been used for the playground and play area. We've never used.
Tim, if you don't mind, that lower
Yeah,
lot.
Mr. Dooley, I'm sorry.
Yeah.
This is now Ms. Couch's time, and so unless she addresses you directly, I'm going to ask that you hold off. You will have a chance on rebuttal to address any arguments or questions that she has made. Ms. Couch, I'm sorry. Go ahead.
Well, and furthermore, that lower parking lot is used for our teachers and our staff to park in.
And what about, by the basketball courts or any areas further into that parking lot? Did you all assess whether or not that was possible? You said the parking lot is used for play, but I guess were any other locations in that parking lot looked at to place this play set besides the one that was selected?
Yes, they were, but again, we're limited on the area we have, and this is already eliminating. I don't have the exact number, but Mrs. McElroy does. I believe we're eliminating 6 or 8 parking stalls to do this. And there's times when we need every parking stall.
Versus how many would you be eliminating if you moved it?
I'm sorry, what was the question?
Did you look at how many spots you'd be eliminating if you moved it?
To the lower parking lot?
Or over towards the basketball hoops?
It would probably be about the same number, but again, from a safety and a logistics perspective, that location does not work.
Okay. And then I just wanted to clarify one thing. You mentioned that you weren't sure why this was an issue because of a front yard, but I believe the issue is that it's a side yard. Is that right?
Agreed, but to us and to the parish, it's existed there for over 100 years. That's the rear yard for us, not a front yard. So I think we just disagree inherently that this should be considered a front yard of our parish.
Okay, I don't have any other questions, Mr. Shirky.
Okay. Great. So why don't we go ahead and give our zoning plans examiner, Walton Mueller, an opportunity to weigh in. And then I'll give the attorneys, if they have any questions of Walt, I'll give them an opportunity to ask him some questions.
Okay, my report pretty much states our position on this. The question about front yard is anytime you have a lot that fronts on a legal street, that is considered a front yard legally. I know they consider that the rear yard because their addressing is up on Beachmont, but legally we determine lot frontage is based on frontage on a legal street, and that is a legal street there, just to answer that question for you. I did share my screen earlier that showed a proposed location, old location, kind of gave a general idea where it was. We are recommending approval for this, but are asking that they provide some type of fence screening along the street there that would mitigate some of the issues I believe that the neighbors have. Other than that, that's all I have.
Okay, thanks, Walt. Mr. Carville, any questions for Mr. Mueller?
No, and just as a point of clarity, we're here requesting the variance because it's the most expeditious way to resolve the issue. We just want to make sure we're preserving the argument regarding rear yard versus side / front yard. That's the purpose for bringing up that testimony.
So you want to preserve the argument that this is in fact a rear yard. And,
yes, sir.
And therefore a variance is not actually necessary. But even if it is considered a front yard, you're still entitled to the variance.
That's the correct legal argument. I just don't want it waived.
Sure. It's noted for the record. Thanks,
Okay.
Mr. Carville. Sure. No other questions?
No, sir.
Okay, thanks. Ms. Couch, any questions for Mr. Mueller?
I don't have any at this time. And I just wanted to clarify that
Ms. Couch, I'm not sure if you can hear us, but we lost you there.
Can you hear me?
We can hear you. I can hear you now. It looks like your connection slowed down there for a minute. I heard that you didn't have any questions, but I didn't hear the
Yes,
second part.
I did want to make a brief statement as to our position statement, as well as my client, and I didn't know if we should handle that after Mr. Moeller or when you'd like to handle that.
Yeah, so the floor is actually yours now to present any witnesses, make any opening remarks or any arguments that you'd like to make. And just like Mr. Carville, you can orient it however you want. If you'd like to ask direct examination questions of your witnesses, you can, or if you just want to give them the floor to testify, you can also do that. It's completely up to you. Whoever does testify, Mr. Carville will have an opportunity to cross-examine them if you would like. And then after that, we'll move into closing statements.
Excellent, I appreciate it.
Sure.
So, we've presented our position statement as well as the exhibits, which I'd ask be incorporated into the record at this point in time. But just to kind of gloss over those and give you the big highlights, if you will, this variance is asking for something that the zoning code outright prohibits. They're not asking for an extension on a setback or a height requirement. It's actually something that is strictly prohibited. And I think that's really important to point out. Additionally, there's been a lot of talk about there being a playground on the property for many years, so on and so forth. But the problem we're having is that all of those playgrounds, if they were in this vicinity, were an unlawful use without a variance. So there cannot be a non-conforming use if it's an unlawful use. And frankly, that's how we view the 2004 playset that was there, that was just recently removed. Because it was unlawful, it can't be non-conforming. And since they've removed it, it can't be non-conforming. So I just feel like that's a point of clarity that we wanted to discuss because there's been so much testimony so far about this being used for that purpose for so many years. I think we laid out in our position statement that the Duncan v. Middlefield standards for practical difficulty pretty clearly. So we'll just stand by our position statement on those. But I think our biggest issues are, buffering, number one. We feel like there's a reasonable alternative here, and that Guardian Angel has failed to investigate those reasonable alternatives. We feel that just simply shifting this play set to the left inward, where there's already areas for it, where previous play sets have already sat, would be beneficial in a number of ways for the neighborhood, but specifically for my clients. The buffering is obviously an issue. There were a couple evergreens that were planted there for aesthetics, 5, 6, 7, 8 years ago that have been allowed to overgrow, but they aren't buffering for sight or noise. They're simply there, frankly, like I said, for aesthetics. And then the hours of operation are a huge concern. There are kids on there from 8 a.m. till 10 p.m. Screaming, yelling. This place set is 50 feet from my client's home, and it's loud at all times. We'd like to go ahead and play one of the recordings if that's permissible at this time that we've submitted to the record.
Sure.
Okay, and I'm actually going to play on my client's phone because it seems to be a little.
Can you tell me exactly what this is?
Yeah. Well, if I can ask my client real quick, and I'll just establish that. Ed, can you tell me what this recording is?
Yeah, I made this recording at 8 p.m. was just in my front yard. I think I taken my dog out and kids were playing on the other side of the bushes. I think there was a football practice. So these are the kids that probably have come with their parents and are, running around having a good time. And I just took my phone out and started recording and recorded for 2 minutes just because I could hear the noise and the disruption. And I thought it was important that maybe for this hearing that you all could hear what we hear on a regular basis.
Okay.
So just to summarize, that's what my clients are hearing in their front yards and in their homes. Like I said, pretty much at all times of the day, from the time that kids are being dropped off until sometimes 10 o'clock at night. That's what's being heard. Again, we've talked a little bit about this, but we feel like there's a reasonable shift that could eliminate a lot of these issues. Even kids playing basketball on the property right now, there's not that kind of noise going to my client's house. But placing this place at 50 feet from their homes is going to perpetuate that for another 17 years, like they've been dealing with. There's the issue of the hours of operation of the playset, of supervision. If it's going to be open to the public, there's no way to seemingly lock that down. And like I said, there's a lot of people on that at 8, 9, 10 o'clock at night, whether they belong to the parish or they're open to the public. So that combined with the buffering issues, as well as the fact that, you know, my clients have been subjected to that kind of noise every single day for the last 17 years because the last playground was installed unlawfully. So I think that's kind of the gist of the legal argument there. And if my client would like to make a brief statement.
Sure.
My name is Ed Stewart. I've lived at Brackman Avenue at 1651 for the past 33 years. I'm speaking to you today on behalf of myself, my wife Cecilia, and my neighbors Ken and Sue Kramer. I graduated from Guardian Angels School in 1965. I'm currently a GA parishioner, and 4 generations of my family have been GA parishioners. While we're supportive of the parish generally, we cannot support this new playground for so many reasons, and I'd like to mention a few of them right now. First and foremost, the new and the former playset locations too close to Brackman Avenue homes. The playset being proposed in the prior playset is 50 feet from my front yard. This close proximity has caused problems over the last 17 years. In 2004, when the original playset was built, we were not notified or afforded the opportunity to voice opposition. We now know that is because Guardian Angels did not follow the proper procedures for building it. Had we been notified 17 years ago of the original playset, we would have opposed it then, as we are now. Unfortunately, that was not the case, and we were subjected to 17 years of extreme noises. As I indicated, the biggest issue we have is the noise. To be clear, this is just not some laughter of children in the distance. We've been subjected to high-pitched screaming every day, all day, from that day prior, from the day that prior playset was installed until it was torn down. It's so loud, in fact, that when I stand in my house, it's often hard to hear my wife talking to me or hear anyone on the phone. This new playset area will be twice as large. I'd like to just make the point that the playset's moving, but in its place, a permanent structure is going in, called a Gaga pit. So in effect, we're doubling the size of the area that the playset will be sitting in. The new playset, as you've heard from the recordings, this is not a small amount of noise, nor is it only sometimes. The playground is used at all times of the day, including for after school and nighttime sporting events. It's extreme and perpetual. The noise is compounded by the fact that there's no buffer in between our properties and the playset. When the previous playset was installed in 2004, Guardian Angels planted some small shrubs along its fence line for aesthetic purposes. Now those small bushes, mostly consisting of honeysuckle, have become overgrown. Guardian Angel may think that these overgrown bushes are down the noise, and additionally, they barely cover the proposed area for the new playset as seen by our photographs. When I first learned of Guardian Angel's intent to build this new playset, I reached out to Mark Belli, Guardian Angel's business manager to discuss it. Mr. Dolly told me it was not my concern, and Guardian Angels owned the land and could do whatever they wanted. He also told me that I was not to communicate with Liz and Tim McElroy for handling the project for the parish. Unable to work cooperatively with the parish, we've been forced to hire counsel and proceed to officially oppose the variance. We do not want to prevent Guardian Angels from building a playground. We simply do not want it 50 feet from our homes. Guardian Angels owns 11.5 acres. There are plenty of alternative locations for this play set, not the least of which is simply shifting it over towards the inside of the property, where prior to 2004, there was an original wood play set. In addition to this location alternative, it is important to us that restrictions be placed on the use of the play set. After school hours, when the play set is open for public use, there's no supervision. According to the National Program for Playground Safety's Safe Framework for Playground Safety, quote, since equipment can't supervise children, it is important that adult supervision is present when children are playing on the playground, end quote. However, there's nothing in Guardian Angel's application to indicate how it intends to supervise the use of the play set. Additionally, there are no posted hours of operations and rules. The playground is used all hours of the day and night. In GA's variance application under playground equipment product description, it states, quote, transform your school into the playground that never sleeps, end quote. Our concern is that this play set is going to continue to allow excessive noise at all times of the day and at night during the evening sporting events and after school activities. In conclusion, we are asking the hearing examiner to deny this variance application, or in the alternative, to set conditions on its location and use so we don't have to live another 17 years here in distress because of the extreme screaming penetrating our homes. Thank you.
And
Thanks,
I
Mr.
have
Stewart.
nothing further, David.
Okay, I just have a couple questions, probably for Mr. Stewart, but Ms. Couch, you may be able to answer some of these. So, Mr. Stewart, is it the noise that is the primary adverse effect of potential adverse effect of this playground installation or playset installation?
Yes.
Yeah, it's the noise you said, sir.
Yeah, is it the noise or the
Noise
appearance?
is the main concern, yes, sir.
Okay.
And it's, the playground with the play set, it concentrates the children in front of our homes versus being spread across the playground. Like Emily had mentioned, there's basketball poles, probably, or courts 100 feet into the property from our house. Last night they were shooting baskets. I could hear them, but it's so less obtrusive being further away like that versus being right in front of our homes.
Got it. And how long have you lived at your home?
33 years, since May of 1988.
Okay, and you said this was installed in 2004?
Excuse me, I'm sorry.
You said that the existing place that was installed in 2004?
The
old place set, the one that is either existing or was recently removed?
Yes. What about the 2004 play set?
Do you believe it was installed in 2004?
Yeah, I know it was, sir. There's a sign that it was dedicated to one of the employees that is laying on the ground next to where it was torn down. And I looked at it, took pictures of it with my phone, and it was dedicated and built by the PTA in 2004. And I've got a couple pictures of that.
Okay. And Ms. Couch, you may be able to help me with this. So the modern zoning code was instituted in 2004 or adopted in 2004. And so how do you know that this old place set was not grandfathered in?
But frankly, we don't know for sure about the exact date of the installation versus when the zoning code was implemented. But once they rip that out, they lose any non-conforming use. So once that old place set is ripped out, this new one is subject to the zoning code. So it would have to adhere to that. So there really is no non-conforming use here.
Sure. I thought someone had referenced that the old one had been installed illegally, and I just wanted to see if that was verifiable.
We think that it was unlawful. However, I'm not sure the exact date in which the playset was installed. We just know that they both occurred in 2004.
Okay. And Mr. Moeller, in his report, made a recommendation for some privacy screening and some fencing. Do you have any response to that? I know that you want the variance denied and you don't want to place that in that location at all, but do you think that that would mitigate any of the noise that's at issue here?
Maybe a little bit, and it really kind of depends on the height and the, how extensive that buffering area is. But our concern is also the hours of operation here, as well as the fact that we're a little concerned that it's going to be hard to buffer that noise, given how close that place at their home, to give the relief that my clients are seeking.
Okay. All right. Thank you. I think that's all the questions I have. I'll give Mr. Carville. Mr. Carville, do you have any questions for Mr. Stewart?
I do have some follow-up. Mr. Stewart, by way of introduction, my name's Chris Carville. I represent GA, and I have about 3 or 4 questions for you. When you moved into your property in May of 1988, you understood that you were moving into a neighborhood that had both a parish and a school across the street. Is that accurate?
Yes, sir. As I said, 4 generations of my family have gone there.
And with regard to the recording that was played, what was the date of that recording?
Can you give me a second to pull it out of my phone, sir?
Take your time.
August 3rd, 2021, 7:56 p.m.
7:56. And do you know if there was a playground in operation on August 3rd?
What does a playground in operation mean, sir?
Was there actually a physical playground that children were playing on August 3rd?
Mr. Carville, do you mean
They were playing in the Gaga pit, which has been put directly in front of our house, where the new jungle gym is supposed to go, and it sat there all summer.
Okay. And do you have a decibel reading on that noise? Does your phone or whatever recording device provide that information?
It was my telephone. I don't know if that has one.
Okay.
I don't believe it does, but I can do it once again, look at the details if you'd like me to.
No, that's all the questions I have, Mr. Sturkey. Thank you for your time, Mr. Stewart.
Okay. And I apologize. I think I misspoke earlier when I said that we would go right to closing statements. Mr. Carville, you do have an opportunity to present any witnesses if they would like to rebut any of the testimony from Mr. Stewart before we go into closing arguments. So rebuttal.
Yeah, sure. Mark, let me do a share screen. This will be very brief. All right. Mark, can you see that?
Yes.
All right. And when children are dropped off in the morning, they come down with my cursor here down Bachman Avenue and make basically a left-hand turn and a right-hand turn and then loop around as I'm showing with my cursor. Is that correct?
That is correct.
All right. And the area that's locked off is where I'm showing my cursor that separates this overflow parking lot from the rest of the parking lot.
That is correct.
All right. And one of the reasons that we're seeking to place the playset in its proposed location is that it does not impede traffic as parents are dropping their children off in the morning, which is occurring with increased frequency during COVID. Is that correct?
That's correct. And other events that take place on the campus throughout the year.
All right. That's all the questions I have.
Could you leave that up, Mr.
Sure.
Carbo, for a minute? Mr. Dooley, I believe that the neighbors have suggested just moving this to the right. I don't know if this is north-south oriented right now, but it would be to the east near the basketball courts. Why, you said it was a safety issue, but why exactly couldn't it be over there?
I guess from my standpoint, for two reasons. First of all, we'll have 9 buses lined up that go out that opening at the end of where the basketball hoops are. They actually leave the campus through that rear entrance out onto, I'm blanking on the name of the street back there. So we didn't want the playground to have cars around it on 3 sides. You know, anytime the kids would be playing, cars would only basically be on the one side. So if we moved it further out, we're either impeding the buses that flow through there at the beginning of the day, at the end of the day, and again, other events that take place on the campus throughout the year.
Okay.
And just as a quick point, the rear lot, the spaces down there are used by 2 different gymnasiums. That's the other reason why the lot on the lower end, I mean, we barely have enough spaces to handle the events that are handled, because there are 2 gyms down there, if you will. And one is also can be used as a parish center for different events.
Okay. And how much is this place set used by the public or children that are not a part of the school? Mr. Dooley, you're muted.
Yeah, I don't necessarily know that I have an answer to that. Since Father King is more of a resident here, he might have a better answer. How often the playground is used by local children?
It's not that often. I mean, the kids, some come up, some of the neighborhood kids use the basketball courts, and maybe some of them are ours. But that's, usually in the evening, after school. It's used during after school, of course, for the after school program. But the playground itself, I haven't, for what it's worth, I haven't seen it been used too much by anybody other than during school time, or if we're having some kind of function on the property, like a picnic or something like that, then the kids are over there playing. But there aren't that many children who come up here just to play on the playground that I've noticed.
Okay. And according to Mr. Stewart and his recording, sometimes the playground is used as late as 8 or even 10 p.m. Is that your understanding from the school officials?
And I'm not here at those hours. Father would.
I'm not going to argue against that. I don't know. I'm not usually out on the property at 10 o'clock at night. So for what it's worth, they don't bother me. I haven't had any complaints from the other people who live or sleep in the rectory at different times, but that might be true. I don't know. I have not. I've seen them in the evening, 6, 7, 8 o'clock maybe, and really I don't know if there's that much light out there for the late night stuff, but yeah.
Okay. And your intention with this new play set is to continue to allow children to use the play set into the evening hours?
Sorry, he's having trouble hearing.
Yeah, sorry. Your intention is to continue to allow children to use the play set unsupervised into the hours as late as 8 or 10 p.m.
We're certainly willing to talk about, restricting access, quote unquote, unsupervised. I would say most of the time it is supervised. For example, when people are up here with their kids practicing basketball, their younger kids might be up here. So unsupervised might be, again, the truly local children. We're obviously amenable to the idea that, we don't want folks running around the campus at all hours. We just, at this point, we wouldn't have suggested it was a great big problem, because again, Father lives here every day and other people live in the rectory, for what it's worth.
Okay, yeah, and maybe unsupervised isn't the right term, but no school officials enforcing any sort of rules or play or noise or anything like that. Is that right? No school officials present during.
Yeah,
during
yeah,
these
again,
hours.
yeah, for the most part, school officials besides father are done at the end of the business day, if you will. But when the campus is used in the evening, there still could be a teacher that's also in boosters, or there's, the boosters are part of our organization. So I don't want to overstate that they're supervised, but I also don't want to suggest that it's the Wild West either.
Sure. How late do the after school programs go? You said sometimes the after school programs need to utilize the playground or the
So
play set.
the official after school program ends at 6 o'clock. That's part of our extended care program, but the campus is used by the boosters, our parish service organizations, generally till 10 o'clock. That's generally when we ask our maintenance personnel to make sure that the buildings are locked and whatnot.
Okay. Ms. Couch or Mr. Carville, any questions based on my questions?
No, I just want to make sure that there's some clarity within the record. When we talk about where the school buses stage, that would be to this photograph orients north. So that would be to the east along where these basketball courts have basketball hoops. Is that correct, Mark?
That is correct. And where that opening is at the end of that island that has the basketball, that's where the buses actually leave.
Yeah, and then as my cursor goes down this access road and picks up this neighborhood road, that's the point of exit for the school buses.
And that's so that they don't interfere with the parents that are picking up their children.
Right. So there's a safety concern when children are being loaded on and unloaded from buses, as well as their own personal vehicles when they're being picked up and dropped off in the evening. Correct? You're on mute, Mark.
Yes, I would suggest that, a playground that would be sided on 3 or 4 sides by moving vehicles would make it a little less enticing.
Okay. And the current proposed location, because it is not cited by traffic on 3 locations, is the safest option for children at play, which would include able-bodied and disabled children. Is that correct?
That was always the thought, yes. And that's why the playground has been back there. And if you, even through the years, when there was a baseball diamond, it was back there. With football, it used to be a field, and that's where football would practice, just to be out of the mainstream of cars moving.
Right. And that would, safety was a concern when citing the proposed location for the new playground. Is that correct?
Absolutely.
Okay. And when you talk about this lower lot, we see this, the roofs of 2 buildings. One's the parish center to the south, and one's the old gym to the north. Is that, or excuse me, a parish center to the north?
That is correct. So Father Haley Gym is the old structure, and the new structure is a parish center / gym. And actually the new gym is twice the size. So it actually can have simultaneous volleyball and simultaneous basketball.
And you have been on campus during basketball and volleyball games, haven't you?
Oh, sure. My kids all went here, school here, yeah.
Okay. And Mark, would there be any available stalls during a game?
No, the overflow lot would be that upper lot up there. And obviously the walk and everything else, those lower spots are prime.
All right. So when a basketball or volleyball game is going on, it's very typical that all the stalls are filled, and then it's necessary to use the overflow parking area that I'm circling with my cursor here, which is in the center of the photograph, correct?
Yes, sir.
All right. And that was considered when citing the current proposed location for the playground. Is that correct?
That's correct.
Okay, that's all the questions I have.
Thanks. Ms. Couch, any questions?
No, I don't have any questions for Mr. Dooley.
Okay, let's go ahead then and move into closing remarks. The applicant will get the last word here. So Ms. Couch, the floor is yours for any closing.
Absolutely, and I am going to share my screen here just to show a quick picture and reference while I'm
Sure.
see if this works. All right, is that visible for everyone?
It's loading up. I can see it. Yep.
Okay, so I guess in short, a variance is an extreme remedy where there's not a reasonable alternative. And we think that in this case, there is a reasonable alternative. In addition to exploring the other areas, my client's main proposal is to shift playground from right here on the property line area that's already mulched. The school occasionally puts a couple of picnic tables on, which would have ample room to include this play set over this direction. As you can see from this picture, this is where the current Gaga pit is. Immediately across from that is the Stewart's property. It appears that the extension of the playground is supposed to go right here, again, up against the property line.
Ms. Couch,
So what
Ms. Couch, Ms. Couch, I'm sorry. I don't know if it's just me. I'm still looking at the first picture. Is that what we should be looking at? I just lost your cursor there for a minute.
Okay, hold on. Let me.
Are we still looking at the picture with the red bench, red picnic table to the left?
Can you
And
see
the
this
caution
one
tape?
with the Gaga pit on the right?
Gaga pit. I don't know what that. I don't know what that is. So.
Is the red
okay.
bench still
Okay.
visible?
No, it's not. Okay, now I
Okay.
can see that black, the black fencing or whatever that is there.
So that, I guess that's what's called a Gaga pit. I'm not. That's what they say.
Okay. All right.
Directly across from this is the Stewart's front yard. And this seems to be the location of where the new playset is going to be. At least that's how we understand it. And then right here is supposed to be additional parts of the playground. And what my clients are really suggesting is that these two pieces that are abutting this property merely be shifted over. So shifted slightly to the right, or I'm sorry, to the left, if you're looking at these pictures, towards those benches that we just saw in the previous picture, to create some additional yardage of a buffer. And I know Father had mentioned that he doesn't really hear what's going on in this back corner, but he's several hundred yards away from this. They're maybe 50 feet. So the noise is really the problem here. We appreciate the suggestion on a different or additional landscaping and think that that's an excellent idea. Hours of operation we think are an excellent idea, but more specifically, we're requesting that this merely be shifted slightly to the left. That doesn't create a unreasonable ask from our perspective. It doesn't tie into the traffic issues we've talked about. It's simply a shift to the left on an already mulched area that was previously used for some part of the playground in the past. And frankly, that's our position, is that the variance is an extreme remedy here when there are reasonable alternatives, which is to just shift to the left. And that's all we have, Mr. Sturkey.
Okay, thank you very much, Ms. Couch and Mr. Stewart, for your time and your testimony here today. Mr. Carville?
Yes,
in closing?
sir. In closing, we would simply ask that that you follow the staff report's recommendation. We are willing to incur the expense of an additional fence to provide buffering. Frankly, we're open to some form of signage with regard to hours of operation, but the devil's always in the detail in that regard. We're wholeheartedly behind the fencing. The signage is just a trickier issue. With regard to citing the location, just so we're clear and that the record is clear, this proposal to move it to the left, given the orientation from Ms. Couch's photograph and this aerial, which is GA 3, that actually means moving it towards the east. And it's not as simple, and I want the record to be clear on this point. It's not as simple as moving the playground over on a mulched surface. We have to put it out here in the hardscape in order to comply with current standards for safety on playgrounds, because it has to have this rubber mat of a certain thickness. So our options are limited with regard to siting this playground or play set on a hard surface, on a hardscape, depending on your industry terminology. So moving the proposed location to the west creates a traffic control problem for us that, frankly, we believe the evidence indicates that we considered. So when we're talking about siting a playground is a location where children are going to be playing, and we all know that children are not going to watch out for their own safety. So we have to consider safety along with neighbors' concerns when siting this particular playground. And we believe that we've picked the safest location for children, especially children with handicapped children that can't react very quickly. We're getting them out to the best of our ability. We're getting them out of the flow of potential traffic. And from a public interest standpoint, we believe that's very significant in your consideration of where this playground should be sited, and from a variance standpoint, subject to the caveat about side yard versus backyard, or front yard versus backyard. So what we're doing is trying to replace an existing playground with a improved, safer playground and pick the safest location for children. And that's what we've done, and that's what the variance proposes. With regard to mitigating its effect on neighbors, like I indicated at the beginning of this closing, we are willing to install the fence that's recommended, and we are open to hours of operation signage. But again, the devil would be in the detail in that regard. I don't believe I have anything further to offer for your consideration from an argument standpoint. We'd stand on our affidavits. We believe they're consistent with the finding in the staff report, and we'd want to move forward expeditiously with recommendations as set forth in the staff report. The final, I did forget one thing, and I knew I was forgetting it. The final thing is this noise issue. We're kind of mixing variances here. We're asking for a site location variance. We're not asking for any type of variance with regard to noise. And we do have in the city of Cincinnati noise ordinances that are subject to certain decibel readings. And we haven't presented any evidence in this hearing that the decibel readings that are in evidence exceed those noise requirements. That's kind of an apple-orange issue here. We want to focus on the siting to the extent it creates these mitigating factors with regard to sound. I believe it's incumbent upon those objecting to the variance to indicate that the sound that's being created does in fact violate existing zoning ordinances or ordinances that apply to sound. And with that, I'll conclude.
When I'm making a decision about particular neighborhood compatibility and public interest, I do have to consider adverse effects. Wouldn't you consider sound and the noise that he played on the recording to be an adverse effect that I should consider? Or are you saying that I shouldn't consider noise at all in this?
No, it is a consideration that needs to be accounted for, and we're willing to mitigate that voluntarily with the fencing as proposed by the staff report. The reason I'm bringing it up is that there is an ordinance out there that spells out what the decibel readings are, that it's kind of a common understanding or a community understanding legislatively with regard to what an adverse decibel level would be. And that's the reason I bring it up.
Got it. Okay. Anything further?
No, sir.
Okay, great. Well, I want to thank everyone again for your time and your testimony here today, and the presentation from the attorneys. So I'm going to take this under consideration, review all the evidence and testimony, and I typically will render a decision within 2 weeks. I am currently running a little bit behind on that, but I'm hoping within the next 2 weeks I can get caught up. So as soon as I finish these decisions, I put them into a PDF and I email them to everyone that's in the hearing. And so you all have a copy of this really just moments after it's complete. In the meantime, if you have any questions, I can't take any more testimony or evidence, but if you have any questions about procedure or anything like that, or the timing of the decision, please feel free to reach out to myself or Cassandra Manus, and we can give you an update on timing of the decision or help you with any other questions. Any other questions right now about procedure or anything else? Okay, great.
Yes,
Well, yeah,
this is Roy, I do have one question.
sure.
And I apologize, I've been joining by phone, not by video, but this decision lies with you and you alone. There's not a variance board within the city.
No, the current decision lies with me.
Okay.
If either side would like to appeal my decision, that is an option, and then it would go to a zoning board of appeals.
Okay. Thanks for clarifying that. And then one other item to note is that, you know, our children start school tomorrow. So I understand that everyone in this business and yours included is very busy, but we would ask for a swift decision because we'd like to get this put up for the benefit of our children who currently don't have a play set to play on.
Sure. And again, we do everything we can to try to expedite this process from start to finish. And so I will be doing everything I can to get this out as quickly as possible. But generally, the timelines that I outlined are what I think is a reasonable expectation for you guys. So, all right. All right. Thank you, everyone. I will leave it at that. I hope you all have a wonderful day.